Are we on to 6 now, Mr. Bear?
I'm sorry, my lady.
Are we on to 6 now, Mr. Bear?
No, we're halfway through 5.
Halfway through 5.
And I hope on track to finish on time. The topic I was about to address was the control mechanism or criteria which is suggested by the respondent. And as we read it, I'll just give you the cross-reference. It's paragraph 117 of their case, page 3598 of the electronic bundle. The control mechanism they propose is that there should be some loss, but difficult to assess. So difficulty of assessment. And they say that is a test. We say the Court of Appeal took it into account, didn't make it the test. But leaving that aside, what about its merits as a criterion for whether or not Rutan Park damages should be awarded? The first point I make is that this is a very weak filter, because there are going to be a great many cases, particularly, of course, in relation to covenants against competition, where it will be said with some force that it is difficult to assess compensatory damages in the orthodox sense. And so the immediate problem that arises, if you fasten on this as your key factor in deciding whether such damages should be available, is that the exception is liable to become the norm. And the Court of Appeal candidly recognised this, but with great respect did not dispel it. And the primacy of ordinary damages, if one takes that as something which ought to be maintained, is not going to be upheld. So that's the first problem. The second problem is that there have been, as we've already discussed, repeated assertions of high authority that difficulty of assessment is not a reason not to award compensatory damages, nor, as I think my Lord Wilson observed, is it something which has been taken to make compensatory damages in the orthodox sense an inadequate remedy. So, and I'm sorry if I attributed that to the wrong person, but we've set out some authorities in our printed case at paragraph 25 on pages 69 to 70 of the bundle. They include, and I won't take it to it in the interest of time, a recent decision of the Privy Council where judgment was given by Lord Toulson at volume 2, tab 13, paragraph 44, where he cites some other familiar cases and lays down the strength of the principle that the court should proceed to assess compensatory damages notwithstanding difficulties. And I took you earlier to Mr. Justice Lewison in the Devonish case at pages 579 to 578 of the bundle, paragraphs 29 to 32, where he also made some valuable remarks about the adequacy of conventional damages. Now, the respondent has pointed in its written case to familiar statements that where damages may be difficult to establish, that can justify an injunction, in particular an interim injunction. Of course, we all know those principles, but we say it cannot be right that wherever you would get equitable relief, a Rutan Park award is available. And if that were to be the case, then that would be another revolutionary proposition. And in my submission, the level of inadequacy that is needed to shift from a purely compensatory damages remedy to an injunctive remedy is a different level of inadequacy from that which would be needed to shift, if it's to be permissible at all, from compensatory damages in the ordinary sense to a Rutan Park award. When one looks at an injunction, one is looking at shifting it from a remedy which provides a direct substitute for performance, namely compensatory damages, putting you by money in the position as if the contract had been performed, to direct compulsion of performance. So the underlying interest that's being protected and the way in which it's being protected are the same. It's performance. And so the level of inadequacy needed to shift to the level where an injunction is appropriate is relatively low. By contrast, the level of inadequacy that is needed to shift to Rutan Park damages, whatever their juridical basis, should be something much greater. And the reason for that is that those damages, as I've already submitted, are not based on performance. They're based on something else, whether you call it a loss of opportunity to obtain a release fee or whether you try and say it is the value of the right that has been infringed, doesn't matter. It is still not based on performance. And so the shift needs to be justifiable in a much greater way than simply the way in which we commonly obtain injunctive relief from the courts. The third criticism I make of the difficulty of assessment test put forward by the respondent, and which the Court of Appeals said was at least a factor, is that it is illogical in at least two ways which we've already touched on, so I can take them briefly. The first way is that my submission that root and park damages will be at least as hard to calculate as normal damages, and perhaps even harder to calculate, because they are inherently unknowable in the way that we discussed before the break, and also because the difficulty which is said to arise in compensatory damages, namely how can you work out what the loss is, where you're looking at a complex situation involving customers and various factors affecting a business's viability, that same difficulty reappears in the root and park context, because of course the anticipated loss is something which would have a bearing, perhaps a critical bearing, on the hypothetical negotiations. So one is confronted with the same problems, but so far from being made simpler, they're actually being made more complex to assess, because they now have to be viewed through the prism of people who are hypothetically negotiating at the time, rather than at least having the benefit of hindsight when you can look back and say, well, let's see what, with the evidence available, we're now in a position to detect.
Well, some of us have been looking at Mr. Grantham's report over the short adjournment. Of course, he does, in his analysis, he does reach forward in time quite considerably. He says, well, what would have been negotiated here would be an option for one step to buy your client's new business. And in 2010, 3 years later, that was sold for a large sum of money.
Yes.
An option to buy it for half its value would have been extremely valuable. Yeah. I mean, it read to me almost like an account of profits in that respect, Mr. Bear.
It has been reverse engineered to have precisely that effect. That is why it's been put forward. And
the basic difficulty about it is that the whole of this is a device for putting a money sum on the somewhat speculative question, what has been lost, and it's designed to produce a cash figure, not a hypothetical, highly complex deal involving things other than cash, which might then be turned into cash. But that's an objection to Mr. Grantham's particular way of setting about the job, not an objection to the agenda that he was set.
I agree that it comes in at a second level, because the ultimate question is, can you say that there's a value of the right that's been lost? Nonetheless, it's still relevant to look at it, because if discussions about the value of the right that has been lost shade into the sort of discussion that my Lord Wilson alludes to, and that's what the cases show happens when you have a root and park assessment, then it may legitimately cause one to question whether it's appropriate to take the value of the right infringed as a basis for proceeding. And I'm going to quote back with great respect to my Lord Sumption what you said in Bunge and Idera, that the capital value of the right is not a proper basis for assessing the loss. And in my respectful submission, what you said 2 years ago remains equally valid today.
Well, it's a very different sort of case, but I'm not going to go to that now.
Well, I'm not treating it as a statute, but I do submit that your Lordship put his finger entirely on the button there, and that was, although the facts were different, that the underlying reasoning is still applicable here. And the common law, as you said, values the performance, the benefit of the services that ought to be provided, or in this case, the benefit of the restraint that ought to have been observed. And if one comes back to the mechanism that is invoked here, there's no doubt at all that Mr. Justice Phillips' order says in terms a negotiation involving the release of the covenant. That's what paragraph 5 says. And that is the order which the Court of Appeals said he was entitled to make on the basis that it was, quote, the just response, unquote. And that is what you're being asked to either uphold or, as we say, to reverse. We say that order cannot be sustained by any legitimate process of reasoning consistent with accepted principle or fairness to my clients. And the principle by which it's sought to be sustained is the notion that if you can show that damages of an orthodox kind are difficult to assess, that is a reason then to grant some different form of damages. So it's not in fact suggested, which would be the logic behind the alternative view, that in every case one ought to be able to get loss of opportunity or loss of value of the right damages. I mean, that would be the internally consistent view, to say let us always accept that this is a proper basis for valuing contract awards, contract damages. That's not suggested. So there is an acceptance by everybody that we've got to keep compensatory damages in the normal sense as the default position. And the question is whether there is a sustainable way, a principled way in which you can do that. And we say with great respect, there simply is not. Of course, an account of profits could, in an appropriate case, be awarded, because that's what Blake tells us, although with one exception, Blake remains the sole example where that has ever been done. It wasn't done here, and there's been no appeal against that, but it's there as a sort of long stop in extreme cases. The question is whether the difficulty of assessment is an appropriate filter, and I'm saying it's not appropriate, first because of the difficulty of assessment reappearing, if anything, in even greater form when you conduct the exercise of root and park damages, and the point about the option and whether a judge really has to sit down and work out like some sort of investment banker.
The actual rationale of Blake, although it's not quite put like this, is that that was a case in which the government had plainly suffered no financial loss, but it had, by virtue of the security aspect, an interest in the enforcement of its rights, which extended beyond the recovery of any financial loss that it might suffer. And the only way that you could give effect to the interest which had effectively been destroyed was by an account of profits. So it's a context which is very difficult to translate into anything remotely resembling our case.
It's a non-commercial context, and
Yes.
I entirely agree. There was an interest which extended to depriving the contract breaker of his profits.
It wasn't just a financial interest.
Yes, it wasn't just a financial
It wasn't a financial interest at all.
No, not at all. No, it was something different. But the consequence of that interest was that deprivation of the profit of the traitor was a legitimate consequence. But in the commercial sphere, One Step had absolutely no interest in any profits that the Morris-Garners might make. Their only interest was in their own profits. And if a byproduct of competition in breach of covenant happened to be profit for the Morris-Garners, that of itself was of no concern for One Step. Their only interest was in protecting their own financial position. And so, as my Lord says, that's obviously different from Blake. The fourth point I was going to make against the difficulty of assessment criterion is one that we touched on before lunch, so I can just mention it briefly, which is that it doesn't actually explain the cases. So it doesn't explain root and park, where there wasn't a case of there being some loss, but it was difficult to assess. It was plainly a case where there was no loss. The judge said so. In experience, Hendricks, again, it was a practical impossibility ever to identify any loss, because the nature of the harm caused by releasing Hendricks's early recordings and bigging them up as if they were something of aesthetic interest to those who like Hendricks's music was something which it was impossible ever to assess. And it was in those circumstances the Court of Appeal said, well, you're just unable in the nature of the case to identify any financial loss, therefore we're going to make an award. It might have been in a case for an account of profits, because the facts were ones where there was an interest that the claimant had which could have justified perhaps that extreme remedy, but that wasn't the course that the court took. Now, that then brings me to two further points before I move on briefly to Blake. One is to say that the Court of Appeal, there's a sort of hint in their decision, perhaps more than a hint, to say that even though they don't accept that exceptionality was a criterion for awarding, a precondition for awarding root and park loss, that this case was exceptional. So Lord Justice Christopher Clark said that, but without any reasons, and Lord Justice Longmore said it and did give some reasons. And what we say about that is, first of all, of course, that's only one of our two criteria. Secondly, it contradicts the judge's own approach, which, as Lord Justice Christopher Clark pointed out at his paragraph 82, was one which involved the absence of any finding that there was something exceptional about this case. And thirdly, we say there was nothing exceptional about this case. the legitimate interest of the covenantee, one step, was no greater than that of any other business which takes a restrictive covenant, either from a seller or from a senior employee. And it's just an interest in their own profit, as I said a moment ago. Lord Justice Longmore said, well, this is a case of deliberate breach. Now, I need to make the point that Mr. Justice Phillips, at paragraph 97 of his judgment, paragraph 109, page 199, paragraph 97, had expressly refrained from making any finding as to whether the appellants were in knowing breach of contract. He'd been asked to make such a finding in relation to a claim for tortious conspiracy, where it said the two of them had conspired to break the contract. And he deliberately refrained from making such a finding. He said, well, I don't want to have to go into that issue, and it's not necessary for me to do so.
Unless one regards this as a punitive jurisdiction, what would have been the relevance of a finding of that sort?
None whatever. I was simply making the factual point because my clients are entitled to point to it. But my Lord is entirely right if I've got the gist of what you're saying. My submission is this, that the deliberate nature, the conscious nature of any breach is neither here nor there in any contract cases, and that's been the law for a long time. See the Mr. Justice Blackburn, no less, in Sykes and Wilde, which is cited in paragraph 24 of our written case. And then Lord Justice Longmore also said that there was the claimant had been deprived of the ability to obtain an interim injunction. That's not based on any finding that Mr. Justice Phillips either made or was asked to make, and it's not very clear, with great respect, what it was that he meant. Again, there's nothing in this case which is exceptional. The business was set up by my clients during the course of 2007, and as is normal, they didn't advertise the setting up of their business before they'd done it to the competition. That's absolutely standard. When the business was detected by One Step, they wrote, or their then owners wrote, solicitor's correspondence, which I've referred you to earlier in Appendix Part 2, Tab 19, which started in January 2008, and there was vigorous correspondence where it was asserted that my clients were in breach of covenant, and they put forward defences to that. Nothing in that correspondence stopped One Step from applying for injunctive relief had it so chosen, but for whatever reason it didn't. We say it doesn't really matter, and that shouldn't be a factor affecting damages, even if, which is not the case, it were applicable on the facts. The final point I wanted to say is that Mr. Orr says, well, there was no suggestion below that the precise criteria of no identifiable financial loss and exceptional case were put forward, and therefore this issue needs to be decided again either by you or by the court. We say that's not correct. If you look, and I'll just give you the reference, at pages 3729 to 3730 in the additional documents, paragraphs 353 to 354 of the closing submissions, not mine, but those which were made on behalf of the appellants at trial, one can see that there was clear invocation of the need for identifiable financial loss and exceptionality by reference to the decided cases and citations from textbooks. So we say it was up to the respondent to obtain any findings from the judge in that regard. It hasn't done so, and if those are the correct criteria, then it's plain that the respondent has not succeeded in its case. Can I now turn then to the problems which persist on any approach, which I've touched on already, so I can just try and group them together. Heading 6, my lady. I'm gradually learning the rules. The first is that we say there's inconsistency with basic principle. That is to say, the basic principle that you get damages for breach, not damages for the right, but damages for breach. And that is in our written case, paragraphs 77 to 79 and paragraphs 96 to 103. Pages 84 to 85, 103 to 105. There is one specific point I'd like to bring out in addition to that, which is in relation to the impact of subsequent events. We touched on it briefly this morning. If you go to page 96 of the core bundle, paragraph 80, subparagraph 4, we make a point which I submit applies however root and part damages are conceptualised, whether it's loss of a bargaining opportunity or whether it's trying to value the right in question. And we say that the nature of these damages as compensation for loss of a bargaining opportunity is undermined, even within its fictional constraints, by the ability of the court to take into account facts and events after the date of the hypothetical negotiation. And likewise, the practice of the court to reduce such damages on account of the claimant's delay in coming to court can't easily be recognised with any exercise of compensation. So if one is trying to value the right, then the right is valued at the date when it arises. And if you take into account subsequent events, then of course that is part of the philosophy of compensation. You're looking to see what actually happened. And the logic of doing that is then that you're not valuing the right, you're valuing the non-performance of the contractual obligation, which I say is the correct approach. We say that that also points the way towards the distinction from property rights, which my Lord Sumption raised this morning. Of course, when it comes to property rights, including intellectual property rights, the court will award user damages. In our case, we in fact put forward a basis. It's paragraph 99 on page 103 of the core volume, under which we say that user damages can be perfectly plainly understood as compensation for the loss of control. I'm the owner of property, somebody takes it, whether it's the horse or whether it's an infringement of my patent, and that person has deprived me of the right to control my property. The damages that are payable for that are therefore a reasonable fee which I could have charged for his taking it.
A patent infringer is not appropriating property, even in a figurative sense. What he is doing is competing unlawfully, just as these parties were.
The patentee has the right, which is conceived of as a property right.
Absolutely, the patentee has a property right, but the property right hasn't been appropriated. The infringer hasn't, so to speak, taken some part of the patent rights and exercised the rights of a patentee. What he has done is unlawfully compete, cautiously.
What he's done is unlawfully to take the exclusive right to make the patented article within the relevant term.
He hasn't taken the exclusive right. That remains in law the patentee's right. What he has done is infringe it.
But if he's, well, my lord, I'm going to press on. My submission is that if he's made the patented article, then he has taken the right, and that's why he is given the ability to obtain user damages. I was going to make the submission that a contractual right, however one conceives of patent cases, and it may be that they can't be completely tidily arranged, contractual rights are different. They are just the correlative of the obligation to perform. The contract contains obligations to perform. And the proper remedy for breach of a contractual right is a restoration of the benefit of performance. In other words, to put the promisee in the position, so far as money can do it, in which the contract had been performed. And as I said a moment ago, the capital value of the right isn't a proper basis for assessing loss. If it were a proper basis for assessing loss, then with great respect, it would have to be so in all cases. And there is no valuable or viable, forgive me, reason by which one can identify a principle to limit it, or indeed one should do so.
I mean, that debate, if one looks at the reasoning of Justice Brightman in Bruton Park itself, he recognises that this sort of, the property rights, whether taken or invaded, or whether it's a horse or patent, are in a special category to which this sort of tablet is appropriate. And then his question is, can I extend it to a particular situation of
Yes.
that he's faced with, which on one view is still a question of invasion of a property right. And the question for us is whether really there's any logic in limiting it in that way, and whether we should extend it further into terms of contractual rights.
Yes.
I mean, it is it's a jump from the situation that Mr. Justice Brightman was considering and was his reasoning to a much wider principle.
Exactly. And put another way around, is there any reason, not so much logic in limiting it, but is there any logic in taking it forward? But that's a sort of semantic point. My point is that a contractual right differs from a property right precisely because it is simply the correlative of an obligation to perform whatever the promise is. A property right, by definition, is a right of ownership of some kind, and that does generate a different response from the law. And one can't collapse that distinction without then opening up the Pandora's box and making this kind of award much more widely available. And the sort of limiting criteria are either no limitation at all, the just response tense, or unsatisfactory criteria such as the difficulty of assessing loss. And so one is left. I'm not denying that one could have a theory of contract under which you valued the rights which had been infringed and made requirements to pay for that value. But it would just be a completely different theory from that which English law has adopted for many decades and centuries. And if one were to go down that road, then there is no shrinking from the consequence, I submit, with great respect, that one would be adding enormously to the burden of everybody who has any contractual obligation at all. It would be a massive increase of a kind which, with great respect, even this court might want to hesitate long before taking. It would be to introduce a completely new animal into the legal terrain, and one which would have huge consequences. And so the question is, can you find any clear basis of principle? And I've been submitting that you can't in any way that is at any rate consistent with the normal conception of contract. And so that finally, if I can just make a few points on Blake. As we all know, of course, in Blake, the court was asked to and did award an account of profits against the spy. It wasn't asked to, at any stage, make a Rutan Park award, and the idea of a hypothetical negotiation between government and Blake is not just absurd, but abhorrent. So it didn't arise in any meaningful way, but I fully acknowledge that Lord Nichols said, in the course of deciding that an account of profits could be awarded, that Rutan Park, in his memorable phrase, shone as a rather solitary beacon, showing that damages in respect of the benefit gained by the wrongdoer could be awarded in contract as well as tort. Now, 2 points to make immediately about that. First of all, Rutan Park was not a contract case. It was plainly damages in lieu of an injunction. Secondly, Lord Nichols was conceiving of Rutan Park, therefore, as a case where some sort of at least partial disgorgement of the benefits was being awarded. And that's a different theory from saying let's value the right which has been obtained. So he doesn't seem to have approached it on the basis which it's now being put forward. We say that what Lord Nichols said about Rutan Park in Blake was obiter, and that it shouldn't be followed. And in the alternative, we say with the very greatest of respect that if it was by some alchemy part of the ratio, that this court should not follow it.
And the basic problem about Lord Nichols' analysis of Rutan Park is that he regarded it as a case of restitution, which, frankly, it doesn't seem to be. In this particular respect, the reasoning of Lord Hobhouse, who of course dissented, seems a bit closer to the mark, because Lord Hobhouse did regard it as a contract case, and which in fact it was. I mean, you're quite right to say it was in lieu of an injunction, but it was in lieu of an injunction to enforce a contractual obligation.
Well, not quite, my lord, with great respect. It was a restrictive covenant, which is a proprietary.
Sorry, you're quite right, yes.
And it wasn't between the parties. So, and ever since Tulk and Moxhay, it's been accepted that it is a proprietary interest. So I do say that Rutan Park is distinguishable.
But do you deny the availability of damages assessed on that footing in lieu of specific relief in a contractual setting?
I'm sorry, my lord.
Are you denying that it would have been possible in Rutan Park to, are you denying the possibility of damages under Lord Cairns Act, or now Section 50, on that footing in a contractual case? In lieu of an injunction, for example.
No, if it's in lieu of an injunction, then my submission, it can be granted.
Right. So the division isn't really property versus contract. The basic division is equity versus common law.
Well, also the statutory substitution power versus common law. Absolutely.
Yeah.
And on that basis, Rutan Park can be sustained, although it can also be sustained on a proprietary basis. But we say that the basis on which Blake was decided doesn't constitute any reason to decide this case in favour of the respondents, and it appears to have followed a different path. And in fairness, there was little focus on Rutan Park in the course of the argument, as far as one can see.
Would it be fair to say that Rutan Park was also a case in which the landowner had an interest in performance of the obligation, it doesn't matter for this purpose what its classification is, which extended beyond the recovery of any compensation for breach? Because the landowner's interest in laying out the mini estate the way he had was presumably concerned with the maintenance of amenity on the land.
The difficulty with that is that Mr. Justice Brightman expressly held that there was no need to grant an injunction in order to preserve the integrity of the scheme. I think I took you to that passage just before lunch.
Well, that was because the injunction, an injunction essentially to undo the damage, would have been wholly disproportionate.
Well, as
Didn't
I
he
read
go
it,
further than that?
yes.
He said, look at the way this area has been laid out. There's no need to prevent this development in order to maintain the integrity of the restrictive covenants that apply to that area, didn't he say?
Yes, as I understood it, and given the way in which the land had been used before for sort of burning household rubbish, it wasn't as if anything was being done which would, and permitted to remain, which would undermine the integrity of the scheme. So I think what he recognised in my submission was something simpler than my Lord Sumption has put to me, which is simply that I've found this to be a valid obligation, and in principle I could grant an injunction, but it would be against common sense to do so. However, that would confer some sort of unfair windfall on the developer, and I'm going to make an award instead. And it was as broad brush as that, that it just, I have the power to do it, and I'm going to reach a figure which I've reached on a fairly intuitive basis, 5%, not very much, even in those days, and I'm going to award that. And it wasn't, in my submission, done on any greater basis than that. And one can see that, just coming back to a final point, because I'm conscious that Mr. Orr will be changing a bit, that Blake and Rutan Park at that level could be explained, and I'm going to take you to one case, and for 2 minutes, if I may, just to make this point.
Well, they come off your reply time, so it's up to you.
Very well. Thank you for making that plain. I'm going to take you briefly then to the Swinson case in Volume 5, tab 66. At page 2063 to 4. In my Lord Sumption's judgment, where at paragraph 14 on 2063, reference was made to the principle of transferred loss, which obviously we're not directly concerned with, but as is said, the principle of transferred loss is a limited exception to the general rule that a claimant can recover only loss which he has himself suffered. And then reference made to the Albazero and subsequent cases, which created an exception to that, allowing somebody to recover for someone else's loss. And paragraph 16 in my submission seeks to provide some sort of underlying explanation for that. It's important to remember that the principle of transferred loss, whether in its broader or narrower form, is an exception to a fundamental principle of the law of obligations and not an alternative to that principle. All of the modern case law on the subject emphasises that it's driven by legal necessity. It's therefore an essential feature of the principle that the recognition of a right in the contracting party to recover the third party's loss should be necessary in order to give effect to the object of the transaction and to avoid a legal black hole. So one can see that in some cases, maintaining a theoretically consistent structure has to give way to the demands of practical justice, but that is set at a very high bar where you've got what my Lord Sumption called legal necessity, or to use the metaphor, a black hole, which therefore needs to be filled, if that's what one does with black holes, or at least steered round. And one can see that Blake might be regarded as that, which would also explain why, other than one first instance case shortly afterwards. Blake has never been followed, and there's no other case, with the exception of one I mentioned, where an account of profits has been ordered for breach of contract. But if it hadn't happened in Blake, one can see that the end result would have been undesirable. And so sometimes it is permissible, but it's got to be done only in the most extreme cases. And other than that, the law of obligations should be given an internal coherence. And for the reasons I've attempted to set out, we say that the Court of Appeal's approach here doesn't achieve that, and that it's not possible to rescue it. Our narrow proposition is that limiting criteria could be imposed, which would also rule out the award of root and park damages in this case. But our broad proposition is that ultimately the most satisfactory route is to say that root and park damages as a remedy purely for breach of contract should not be available. And the benefits, if it might be thought there were any, in terms of permitting redress in the occasional case where it was thought to be fair, are seriously outweighed by the fact that there would be a fundamental departure from principle, it couldn't be safely contained, and the end result would be to impose a much greater burden on all sorts of contractual obligors, and in particular, of course, on those who've entered into covenants against competition. And for those reasons, we respectfully request the court to overturn the decisions below.
Thank you very much, Mr. Bear. Thank you.
My lady.
Mr. Bergson? Mr. Orr?
Please, my lady and my lords. I propose to make 6 main submissions and a number of supporting submissions. If I can identify those, my lady and lords, at the outset. Our first main submission is that root and park damages are a valid and principled remedy for breach of contract. They provide the court with an alternative method of assessing damages in circumstances where damages are very difficult or impracticable to prove or quantify on an ordinary basis. This explanation, we submit, fits all of the cases in which root and park damages have been awarded or refused for breach of contract. Our second submission is that root and park damages are readily accommodated within a compensatory framework for contract damages. Like ordinary compensatory damages, they aim to put the innocent party, so far as money can do it, in the position he would have been had the contract not been breached, albeit that they do this by adopting an objective measure of loss. Root and park damages do not therefore undermine the compensatory principle. They support that principle by providing the court with an alternative mechanism for quantifying loss when a conventional assessment would not do a proper job. Our third submission is that root and park damages can also be explained on a restitutionary basis. On this basis, root and park damages operate to reverse the wrongful transfer of a benefit obtained by the defendant from the claimant by reason of the breach of contract. This explanation we submit does not conflict with the compensatory analysis. Reversing the transfer of the benefit wrongfully obtained by the defendant is the flip side of compensating for loss.
It's an alternative, though, isn't it?
Indeed, my lord, yes, it's an alternative. That is a better way of putting it. The hypothetical release fee bargain values both the claimant's loss and the benefit obtained by the defendant. Our fourth submission is that we submit that it follows from our analysis that the appellant's broad proposition should be rejected. Root and park damages are not incoherent or contrary to principle. They should not be confined, as the appellant suggests, to claims for damages in lieu of specific relief or claims for breach of property rights. Any such restriction would, we submit, lack logic. It would be contrary to principle as well as established authority, including the House of Lords decision in Blake, which we submit this court should not depart from. Our fifth submission is that the grant of root and park damages in the present case is fully in accord with the previous case law and is readily justified. In this case, the respondent suffered financial loss in the form of damage to its business and goodwill as a result of the appellant's flagrant breach of the restrictive covenants. The judge and the Court of Appeal were satisfied that such damage had been suffered, but they recognized that the damage would be very difficult or effectively, in practice, impossible to quantify on an ordinary basis. And the respondent faced two particular difficulties in that regard. First of all, it would have been extremely difficult, if not in practice impossible, to reconstruct each of the placement decisions resulting in the referral of service users to the appellant's competing business. By their nature, those decisions are extremely sensitive and nuanced, involving input from a range of people, including medical personnel, care personnel, other local authority personnel, and the service users themselves and their respective families. And attempting to reconstruct those decisions across the appellant's entire client base would have been extremely complex.
I mean, you're referring to the problems of establishing how much of the business that the unlawful competitors did would, if they hadn't done it, have gone to the claimants.
Indeed, my lord, yes. Exactly so. And that is the first ingredient of the loss claimed. But then, as your lordships said earlier, we also claim damages for the ongoing loss that we suffered consequent upon the wrongful competition over and above the diversion of individual placements, and that is best expressed as wider damage to goodwill. What we lost was the opportunity to grow our business because one placement leads to another. We lost market share. All of those matters need to be encompassed in an assessment of damage to goodwill. That is extremely difficult to do on an ordinary basis. And whilst my learned friend makes much of the difficulties on a root and park assessment, what he does not do, what he hasn't done in this court, and he didn't do it in the Court of Appeal, is proffer any guidance as to how damages in this case, or indeed in very difficult cases, could be computed other than in some very broad brush approach, as courts in the last century have referred to as general damages. But that doesn't assist the judge in dealing with a difficult case like this. Our sixth
Can I just be clear? I mean, I obviously understand that a sort of detailed assessment, contract by contract, would be very difficult. But I thought, I mean, I may have misunderstood it, but one of the exercises Mr. Grantham does is to look at it from the defendant, your client's point of view, and say, well, what loss would they anticipate by looking at the position with or without the covenant? Isn't that precisely the exercise you're talking about?
Indeed, my lord, but the conclusion that he comes to as a result of that is he says, in effect, that estimating that impact on One Step's business would have been extremely difficult.
Yes, but he comes up with a figure.
And that is why he went for, suggests the option structure, because he recognizes that this is a case where it would be very difficult to assess the impact of unlawful competition on the respondent's business. And that is why he says reasonable parties in the position of these parties would have adopted an option structure. And that option structure had a comparable in this present case.
I mean, just to make sure I haven't misunderstood it, one goes to the report at tab 25,
yes,
page 329 in the hard copy, and I don't know
yes,
what's in the MS copy.
So,
He has a figure F22, methodology for assessing the notional release fee.
Yes.
And then he has a table which shows cash flows absent alleged breach, cash flows with alleged breach.
Yes.
And those are the sort of exercises he carries through, and he comes up with some figures based on that. Well, isn't that just the exercise that one would have to do if one's trying to assess damages on a conventional basis?
Where this analysis leads, my Lord, which is what I was referring to, is Mr. Grantham's conclusion, which comes at page 333 of the bundle. Because what he's been doing up until this point is he does adopt the benefit of hindsight. And perhaps I should just take a step back to explain the context of these figures. What the respondent produced at trial was two experts' reports, one from an accountant called Mr. Hine. And Mr. Hine assessed what was described as the shortfall in profits. And he did that by assuming, improbably as the Court of Appeal acknowledged, that all of the business that went to the appellant's competing business would otherwise have come to one step. So that's the exercise that Mr. Hine did. So that in itself was hypothetical. It didn't grapple at all with the question of causation, which is the really impossible question on this element of the damages. And Mr. Hine looked at what he considered would have been the impact of all of that business having gone to positive living instead of having come to one step. And he compared the actual position with what the position would have been had the trend at the time of the breach continued. And that's how he came up with a shortfall figure. And so, to some extent, Mr. Grantham adopted those figures. But where he ultimately gets to is on page 333 in paragraph 2.2.28 and 2.230. He says, as set out above, a reasonable person in the position of one step would have assumed that the defendant's competing business would have had a significant adverse effect on one step's profit levels, but it would be difficult to estimate precisely what that effect would be. And that is the crux of the point.
Well, no one disputes that it's difficult to estimate precisely, but no one's suggesting you have to estimate precisely. You have to take a broad approach. Because, I mean, my concern, I'm really seeking guidance, is why it's suggested that the process that you're saying should be conducted, which is a completely hypothetical negotiation, which never happened on a hypothetical basis, is any more certain or precise than the exercise that we're looking at here.
Because, my Lord, on the proposed option structure that we put forward, all one has to have regard to is the actual sale value of the competing business and the extent to which that was attributable to the business during the period of the restrictive covenants. So one is not, in order to compute the damages, one is not needing to factor into the amount of the ward, the precise effect of the competition. All one is looking at on this basis is, in effect, the amount of the benefit that is attributable to the wrongful competition during the period of the restrictive covenants. And that is how the figure at the end of the day falls out. So in actual computational quantum, precise or otherwise, the actual impact of the diversion of business doesn't factor into the quantum process. To that extent, it's a much simpler process. And one can, of course I understand that one can quibble with the precise methodology. But it does in our submission.
That's assuming you can take account of hindsight.
Well, no, we would say not if you're adopting the option structure. Because what Mr. Grantham contemplates is the arrangement being one where only a modest lump sum amount is paid up front, because he accepts one, that the impact of the unlawful competition is going to be very uncertain, and secondly, that the defendants, for that reason, would not be willing to make a large lump sum
Anyway, I think
payment.
probably we better not get too closely involved in the detail of it, but I hear what you say.
And this approach also has some similarity, we submit, with an equivalent approach that was adopted by Mr. Justice Sales in a case called Verco and Rutland Fund Management, where there the claimants claimed root and park damages. There, in fact, the parties agreed to assess damages on a root and park basis precisely in order to avoid the difficulties that would have arisen on an ordinary assessment. And Mr. Justice Sales importantly said that he agreed that that was the right approach in law. And in that case, the
Do we have that one?
we do, my lord.
You don't need to look at it, just
It's volume 1, tab 9 of the authorities. And in that case, the claimants were two...
And your junior will give me a... please forgive
my
me.
lady, it begins at page 807.
Thank you.
Unfortunately, it's not reported, so we don't have a head note, but we have included relevant extracts. And perhaps if I can take the court to page 833 of the bundle, paragraph 306. Now here the claimants were two businessmen who had approached the first defendant, which was a venture capital company, with a business proposal to purchase a business that the claimants had identified this opportunity. And they approached the defendants on the basis that they, the claimants, would be entitled to participate in the purchase. The first defendant went off and purchased the business on its own without including the claimants, in conjunction, and it did so in conjunction with the other defendants. The claimant claimed damages for breach of contract against the first defendant because there were written agreements prescribing the basis on which confidential information and so on would be used by the first defendant. And they also claimed damages for breach of confidence against both the first defendant and the other defendants with whom they had no contractual relationship. Mr. Justice Sales awarded root and park damages against all defendants. And so far as the breach of contract claim was concerned, he did that in order to avoid the difficulties that would have arisen on a traditional assessment. And what he concluded was that in the hypothetical negotiation, the parties would have realized that it was very difficult to predict how things would have turned out. So he concluded that what would have been agreed would have been an agreement by the defendants that the claimants should be given a particular allocation of equity in the business, assuming that the defendants went and purchased it without the claimant's participation.
That's effectively an indirect way of achieving an account of profits, isn't it?
Well, effectively achieving a form of partial disgorgement, but we say, as a proxy for quantifying the compensatory loss, the ordinary compensatory loss, which was extremely difficult to quantify on an ordinary basis. And Mr. Justice Sales said that he adopted that approach at the bottom of page 833. I adopt that approach by application of ordinary principles for the assessment of damages. I would add that it is also an approach powerfully underwritten by the decision of the House of Lords in the Golden Victory. And what we understand Mr. Justice Sales to be saying there is two things. First of all, that this is not inconsistent with the compensatory principle because he's adopting this approach as a proxy. And secondly, to some extent, he is adopting the benefit of hindsight, so having regard to how events have in fact turned out, but only for the purposes of ascertaining what the final figure is. And we submit that by analogy, that is the approach that we have posited here.
And is it powerfully underlined by Golden Vanity?
My Lord, we say it is for those two reasons, that that, to go back to my first submission, that root and park damages are an alternative method for quantifying damages when they're extremely difficult or impracticable to quantify on an ordinary basis. And that adopting the benefit of hindsight is itself not contrary to the compensatory principle, because that is indeed what the majority did in the Golden Victory.
That was in a very different context, wasn't it? Anticipatory breach.
My Lord, Golden Victory was not anticipatory breach. The Charter Party had started. The breach occurred, I think, about 3 years into the 7-year Charter Party.
I think it was a frustration case, wasn't it?
It had 4 years to run. There was a war clause in the Charter Party.
Yes.
And when the Iraq War broke out...
the breach had occurred before war broke out, didn't it? Wasn't that the whole point?
Yes, indeed. The breach had occurred before, but by the time the case got to the assessment of damages, the war had broken out.
So the question really was whether you assessed damages on the basis of the 15 months that the contract actually had to run, or the, I think, 3 or 4 years that it would have had, or the parties would have expected it to run at the time of the breach, because they didn't anticipate that the war clause would be triggered.
Exactly.
But I mean, so it isn't an anticipatory breach, but the actual logic of it is exactly the same. What you have is in the anticipatory breach cases, is you have something which at the time of the breach is expected to produce a particular consequence, but subsequent events show that it would have produced a less drastic one.
Indeed, my Lord. And as we understand it, that is effectively Bungie and Nadera.
Yes.
That was the difference between Bungie and Nadera and the Golden Victory.
But the problem about that, the analogy isn't very close, because the difficulties here arise not out of the duration of the obligation, but out of quantifying the loss of goodwill. And it seems to me that in that situation was really concerned with overcoming a completely different kind of problem.
Yes, a practical problem rather than
Exactly.
than a real issue about the duration of the period of performance.
Yes, my Lords, I accept all that. And indeed, that is the submission I was going to make in response to the appellant's reliance on my Lord Sumption's judgment in Bungie and Nadera, is that Bungie and Nadera and the Golden Victory have nothing to do with root and park damages. And in our respectful submission, my learned friend is taking what Lord Sumption has said completely out of context. Perhaps while we're on this, I can dispose of this point now. Bungie and Nadera is in Authorities Bundle 2. And if I might respectfully suggest the real insight of my Lord Sumption here really arises when one reads paragraph 21, which my learned friend relies on, in the context of paragraph 16. So this was a case of anticipatory breach, and it involved the sale of goods. But what my Lord Sumption said in paragraph 16 is that sections 50 and 51 reproduce the corresponding provisions of the Sale of Goods Act and reflect common law principles which had already been established at the time of the earlier act. And then dropping down to alongside letter E, that situation gives rise to two potential questions which are not always sufficiently distinguished in the case law. The first question is, assuming that there is an available market, as at what date is the market price to be determined for the purpose of assessing damages? And then just below letter F, the second question is, in what, if any, circumstances will it be relevant to take account of contingencies other than a change in the market price if subsequent events show that they would have reduced the value of performance, perhaps to nothing, even without the defaulter's renunciation? So in our submission, that provides the context for what my Lord Sumption said in paragraph 21. And as we understand it, what my Lord was explaining was that sections 50 and 51 of the Sale of Goods Act and the corresponding common law principles were concerned only with determining the price by reference to which damages for non-delivery or non-acceptance were to be quantified. They were not concerned with the separate question of whether subsequent events were to be taken into account when awarding damages for non-delivery or non-acceptance. And that, as we understand it, is why my Lord Sumption says at the bottom of paragraph 21, sections 50 and 51 of the Sale of Goods Act, like the corresponding principles of the common law, are concerned with the price of the goods or services. They are not concerned with the value of the contract as an article of commerce in itself. And in that context, that statement is self-evidently correct, we respectfully suggest, but it has got nothing to do with this case. And the real insight, as my Lord Sumption has said in paragraph 16, was that those two separate questions had not been sufficiently distinguished. And that is the error that the minority in the Golden Victory fell into. But if I can then revert to our submissions, and I was just getting to the end of the recitation of my 6 submissions, and our 6th submission is that the appellant's criticisms of the Court of Appeal's decision should, we respectfully suggest, be rejected, and their narrow proposition should therefore be dismissed. We make 2 subsidiary submissions here. First, we submit that the appellants have misstated the effect of the Court of Appeal's just response test. That does not represent some vague resort to the discretion of the court, but is the means by which the court determines on a principal basis whether resort to an alternative measure of damages is appropriate. And Lord Justice Christopher Clark and Lord Justice Longmore identified in their judgments specific considerations to which the court should have regard in applying the just response test, and in particular the nature and extent of the difficulty the claimant would face in quantifying damages on a conventional basis. And the second subsidiary point we make is that the alternative criteria proposed by the appellants are contrary to authority and flawed and should not be adopted. My lady and lords, turning then to the detail, I propose to start by setting out what we say is the true nature of Rughton Park damages. And our starting point is what we submit should be an uncontroversial proposition that any assessment of damages involves a 2-stage process. The court must first assess whether the claimant has suffered any loss. Second, the court, if satisfied that the claimant has suffered some loss, it must then value that loss, that is, quantify it. The first stage involves the court determining whether the claimant has suffered some form of undesired consequence that should be recognized as recoverable loss. In a breach of contract case, we accept and indeed assert that the breach of contract is not itself a loss. The loss must be some adverse consequence of the breach that is capable of valuation in monetary terms. Once the court is satisfied that the claimant has suffered some such adverse consequence, it then goes on to valuation. And the distinction between those 2 stages is, we suggest, self-evident. We have referred to a case called Milner and Carnival in our written case at paragraph 68, page 3584 of the bundle, which exemplifies in a very clear way this 2-stage process. And that was a case of supply of an inferior holiday. And the Court of Appeal identified that there were 2 particular forms of loss. One, a financial loss in the form of the inferior service that the claimants had received on the holiday. And then secondly, a non-financial loss in the form of mental distress and inconvenience and so on from not having a decent berth and being moved around and so on. But in relation to assessing both of those kinds of loss, Lord Justice Ward explicitly acknowledged that the court was embarking on a hypothetical and fictional exercise. It was seeking to value what is very difficult to value in monetary terms. Substantially the same exercise is carried out whenever the court assesses damages. And we say this distinction is key to understanding the cases in which Rutan Park damages have been or have not been awarded for breach of contract. Where the court recognizes at the first stage that the claimant has suffered some adverse consequence, but that loss is very difficult or impracticable to quantify, then it may adopt Rutan Park damages as an alternative methodology. Where the claimant's loss is financial, those damages represent just that, an alternative method of quantifying loss. In some of these cases, the relevant loss has been the loss of a genuine opportunity to bargain. And in such cases, the court then goes on to adopt the Rutan Park measure to quantify that genuine loss of opportunity to bargain. And Pell-Frischman is such a case. Where the claimant's loss is non-financial, then Rutan Park damages are adopted as a means of quantifying the loss, albeit on an avowedly fictional basis. But importantly, where no loss at all has been suffered, so where the court is satisfied that there has been no adverse consequence whatsoever, then no damages, whether Rutan Park or otherwise, are recoverable. And that proposition is demonstrated by a case called BGC and Rees. It is also demonstrated, we submit, by the outcome in Mr. David Richards' case, Mr. Justice David Richards' case, Abbar and Sedko. Because there the court was satisfied that there had in fact been no adverse consequence from the breach. So the court did not award any damages. And those cases cannot be reconciled, we submit, with the appellant's position. They are inconsistent with the appellant's argument. And the underlying the underlying rationale we submit for resort to Rutan Park damages in these cases is to ensure that the claimant is not left undercompensated. And we submit the law would be defective if it did not permit resort to this alternative measure in these very difficult cases. And that analysis is precisely the analysis adopted by the editors of Chitty on Contracts. If I can ask your lordships to turn this up, it's volume 7, my lady and my lords, volume 7 at at tab 101, at page 2850 in the bundle. And at page 2850, the court will see the heading breach of contract cases, and it's the final two sentences of paragraph 26053. It has been said that the inability to demonstrate identifiable financial loss of the conventional sort is a precondition to the award of such damages. However, it is submitted that Rutan Park damages may also be awarded when the conventional measure of damages would leave the claimant undercompensated. Now, this edition of Chitty predates the Court of Appeal's decision in the present case. But what is significant, we also suggest, is that in footnote 295, the editors refer to the WWF case, where Lord Justice Chadwick said that Rutan Park damages may be awarded as a just response to circumstances in which the compensation, which is the claimant's due, cannot be measured or cannot be measured solely by reference to identifiable financial loss. And those words in brackets are important, and in our submission, they demonstrate the flawed nature of the appellant's reliance on Lord Justice Chadwick's dicta in WWF, because those words in brackets show that Lord Justice Chadwick contemplated Rutan Park damages being awarded in a case where some damages might be recoverable on an ordinary compensatory basis, but not the full extent of them.
What would be the criterion, just looking at the last sentence in paragraph 26053, what would be the criterion for deciding whether the conventional measure of damages would leave the claimant undercompensated?
Lord, in our submission, the criterion, that is saying the same thing as the criterion that we say the Court of Appeal adopted, which is, would damages on a conventional basis be very difficult or impracticable to quantify?
So that in the present case, you might say, well, a conventional award dependent on evidence would not compensate for the longer-term damage to the goodwill. So we can be satisfied that although we don't know how much they would have lost, they would have lost more than the conventional award would give them. But the problem about that is that it assumes that the conventional award is limited to examining the evidence of what extra revenue would have come in but for the breach. And there are many circumstances in which the process of trying to estimate the damages in cases which have a very large speculative and hypothetical element involve departing from the notion that every element of the revenue that you would have got has got to be established by evidence. The court has to draw inferences, and in some cases it has to come to a hunch which it regards as more plausible than any other.
This happens across the field of trying to assess damages.
Yes.
Smith and Manchester damages in personal injury cases.
Yeah.
Good example.
It does so, my lady and my lord. We accept that. But this, as we submit, root and park damages is simply an alternative method of enabling the court to go about that task. And it is principled. And the fact that there may be some that as before root and park, the court simply adopted the broad axe, what are called the broad axe, and came up with some figure for general damages, is no better. That this is an alternative, and we submit principled method, which indeed is itself a form of the court's broad axe.
Well, except that the way that Mr. Grantham does it effectively is to turn it back from an assessment of loss to an assessment of profits that for which it's sought to make the defendant accountable. But I mean, the principle is fine. We're not here to determine whether Mr. Grantham's report makes sense as a matter of law. But I mean, you may not be all that wise to put this forward as an absolute exemplar of the legal proposition you're arguing for.
No, my lord, we're not, and we draw that very distinction that this case is about principle. But even in the context of Mr. Grantham's exercise, we do submit that it is a sensible one, because what has happened here is that the appellants have stolen our business. So it is quite valid, we say, for that reason to have regard to the business they obtained when valuing our loss.
Well, that's a figure of speech. What they've done is compete with you in breach of contract. It's not quite the same thing as stealing our business with the sort of proprietary overtones that phrase is designed to convey.
Well, my lord, we would respectfully submit that it comes to the same thing, that if placements were diverted by the appellants, and we say that is the clear and logical conclusion of the facts of this case, one naturally looks at the value of that business they obtained in computing our loss. But again, that is to turn to the detail rather than the principle.
It strikes me there's an incoherence about the last sentence there. One has to envisage the judge saying to himself, well, on the evidence, I'm satisfied that the loss suffered by the claimant is X. but I'm also satisfied that X is an underestimate of the loss which the claimant has suffered. And therefore, I'm going to embark on a completely different exercise. I think one has to reframe it the way you've done, as really saying, well, I think it's quite difficult for me to arrive at a measure of loss on a conventional basis, and therefore I'm going to allow it to be measured in a different way. But then, you then run up against the broad X idea.
My Lord, well, on the first part of what your Lordship was putting to me, yes, indeed, I agree with it to that extent, that the court doesn't have to go so far as make an actual finding that the claimant would be undercompensated, because then we're not achieving anything. But the court can take a view and form a sensible view as to whether or not a conventional assessment is so difficult that the claimant would be liable to be undercompensated. And then you're turning on to...
But, I mean, difficulty of assessment, and you say, undercompensation, we can't have that. Difficulty of assessment, to my mind, might just as well result in overcompensation.
I mean, actually, this is based, if one looks at note 295, that sentence is based on an observation in Worldwide Fund for Nature, which is actually expressing exactly the point that my Lord Reed expressed a few minutes ago. Not actually talking about undercompensation at all.
No, it's merely a submission by the learned editor of Chitty.
Yes.
To that effect.
But it
not?
purports to be based upon a case which says something slightly different.
Absolutely.
Well,
The giveaway is saying submitted.
Yes.
Indeed, but in our submission, it's consistent with our case, and something similar. I'll come to it in due course. Was also said by the Court of Appeal in a case called Gaffard and Graham.
Am I not right in thinking that almost anything said about Ruton Park damages in the Worldwide Fund for Nature case is obiter? Because what they were deciding was that it was an abusive process to seek to add such a claim at that stage in the litigation.
Indeed, my lady, but it is one of the principal authorities relied upon by the appellants in support of their narrow proposition.
So what?
Which is why we have focused on it.
What's sauce for the goose is sauce for the gander.
Indeed. Well, can I move on then? So as going through our submissions, then our submission is that Ruton Park damages may then properly be viewed as compensatory, and we say that Lord Justice Christopher Clark was right in the present case to describe Ruton Park damages as a form of compensatory damages, although not of the ordinary type. And they're not of the ordinary type because they're measured on an objective basis. And our submission is that adopting an objective approach to valuation of loss is not contrary to the compensatory principle. The negotiation operates as a mechanism for determining the fair value of the benefit to which the claimant was entitled, but of which he has been deprived by the breach. And we say that that is consistent with the fact that the courts have repeatedly said that what compensatory damages are seeking to do is to compensate the claimant for the loss of his contractual rights. And it's true that the breach gives the innocent party a right to damages, which the court will enforce by requiring the defendant to pay damages for his breach, but that does not detract from the fact that the claimant has been deprived of the benefit of the performance of the primary obligation, and that is what he has lost. And that indeed is stated in terms in a case called Aegeus and Quickfit, which is Authorities Bundle 2, tab 12 at page 919 of the bundle, where Mr. Justice Popperwell said at paragraph 30 of the judgment on page 919 that the compensatory principle itself may also be expressed as the claimant being entitled to the value in money of the contractual rights he has lost. The lodestar is that the damages should represent the value of the contractual benefits of which the claimant is deprived by the breach of contract, no less, but also no more. Now, that analysis is, we submit, then reflected in the analysis adopted by Lord Justice Mance, as he then was, in the Experience Hendricks case, which is in Authorities Bundle 1, tab 4. And if I can begin this at the bottom of page 662 of the bundle, towards the bottom of that page, Lord Justice Mance says, he's referring to Lord Hobhouse's view in Blake. He says, as to his, that's Lord Hobhouse's analysis of the damages awarded in the Ruton Park case as compensatory, that designation does not avoid the fact that the damages awarded there, and in other cases such as Lord Shaw's horse, that is, the better for being ridden, cannot be related or limited to any actual financial loss caused by the breach. In the Ruton Park case, the estate owners would never have agreed to any relaxation on any terms of the restrictive covenants. And just pausing there, I do emphasize the reference to actual financial loss. Financial is important because in our submission, Ruton Park can be explained as a case of damages for non-financial loss. And then Lord Justice Mance goes on, whether the adoption of a standard measure of damages represents a departure from the compensatory approach depends upon what one understands by compensation and whether the term is only apt in circumstances where an injured party's financial position viewed subjectively as being precisely restored. The law frequently introduces objective measures or limitations. The former may increase or limit a claimant's ability to recover loss actually suffered. Another situation where damages do not necessarily depend upon precisely what would have occurred but for the wrong is where there has been a conversion. In a case such as the Ruton Park case, the law gives effect to the instinctive reaction that whether or not the appellant would have been better off if the wrong had not been committed, the wrongdoer ought not to gain an advantage for free and should make some reasonable recompense. And then Lord Justice Mance went on in paragraph 45 to quantify the reasonable recompense by reference to the reasonable release fee. At the bottom of page 668, he says, the injunction that has been obtained will protect it, that's the claimant, for the future. For the past, in the absence of any proven loss, I would confine any financial remedy to an order that PPX, the first defendant, pay a reasonable sum for its use of material in breach of the settlement agreement. That sum can properly be described as being such sum as might reasonably have been demanded by Jimi Hendrix' estate as a quid pro quo for agreeing to permit the two licenses into which PPX entered in breach of the settlement agreement. So we submit we submit that that approach is valid and we adopt it. And we submit it provides a coherent and rational explanation for Ruton Park damages. Now, the appellant's response to that is to say that valuing the right is wrong in principle because they say one must have regard to the consequences of the breach. And my learned friend referred the court this morning to an article by Professor Burrows in Volume 8, tab 117, at page 3009 to 3100. Now there, what Professor Burrows is dealing with at that point in his article on Ruton Park damages is not a compensatory or restitutionary explanation for Ruton Park damages, but he is dealing with a quite different thing, which is a thesis by Professor Robert Stevens, that in every case where a right has been infringed, what the court does, or he says should do, is award damages to vindicate for the infringement of the right. Now that thesis is fundamentally different to the way the courts have approached assessment of damages, because it does involve looking at the value of the right in the abstract. And if the court has page 3099, under the heading A Rights-Based Approach to Damages, Professor Burrows refers in the first sentence to Professor Stevens. In his recently published book, Robert Stevens argues that root and park damages are neither compensatory nor restitutionary. And then dropping down a few lines, he says, it is irrelevant to these damages whether the claimant has suffered any loss or the defendant has made any gain, although where they have, these can be added as consequential compensatory or restitutionary damages. The purpose of the award is to vindicate the right infringed. That is not our argument at all. And the reason why it's not our argument is because we absolutely accept and indeed assert that the hypothetical bargain measure must take account of the extent to which the right has been infringed by the defendant. And that is established in the case law on root and park damages, which say in terms that the release fee bargain is a bargain for the release of the right to the extent that it has been breached. And indeed, that is common ground, because that is the way the appellants put it themselves in their written case at page 90 of the core volume. In paragraph 68, in the second sentence, they say the authorities show that the quantum of root and park awards are dependent on the extent of the breach of duty. And that indeed is what the cases cited in footnote 60 establish. Eaton Mansions and those particular paragraphs of Marathon Asset Management. So we are not saying that this valuation of rights approach involves looking at the rights in a vacuum. It must have regard to the extent to which the right has been infringed, and that works itself out in the hypothetical release fee negotiation. And perhaps if I can just at this point come back to the Broad Acts, because we do submit that it would be wrong to distinguish between root and park damages and the Broad Acts. The reference to the Broad Acts derives from Lord Shaw's speech in Watson, Laidlaw, and Pott, Cassels, and Williamson. But what happened there, as the court will know, is Lord Shaw adopted the user principle as a means of quantifying loss in a patent infringement case. So what he was doing there was adopting a proxy method for assessing loss as a form of wielding the court's Broad Acts. In Root and Park, Mr. Justice Brightman cited Lord Shaw's speech in Watson Laidlaw, amongst other user principle cases, to come up with his approach. And so he in turn was wielding the Broad Acts by adopting the Root and Park measure. So that's why we say we respectfully submit it's not an answer to our case to say, well, the court can just use the Broad Acts. This is a means of the court using its Broad Acts, and we submit that this court should endorse that approach.
That's not how Lord Shaw put it. He talks about the Broad Acts as his first principle, compensate principle, and the second principle, which is a property-based principle, illustrated by that if I use your horse, I can pay for it, even if it's not damaged. And that's why all the cases which Mr. Justice Brightman refers are dealing with property cases, yes, treating patents as being a form of property. And then you get that extended by Lord Justice Denning in Strand. But what Mr. Justice Brightman there do is trying to fit his case into a property context, not, as I understand it, sort of exercising some sort of general broad brush approach.
My Lord, I apprehend we are in agreement. The much narrower point I'm making is that Lord Shaw starts off his analysis of damages by referring to the court's ability to wield the broad axe. And it's in that context that he then goes on to adopt the user principle by analogy in a case for damages for breach of patent. Or perhaps we should... It's volume 5.
Could I just ask you, Mr. Orr, you said that the value of the release under the Rutan Park principle is limited to the extent that the covenants have been breached.
Yes, my lord.
Why doesn't that statement require quantification of the breaches?
It requires determination on a liability basis of the breach, and that is what the judge below has done.
Yes, of course.
And what the Rutan Park approach then involves is factoring that into the reasonable release fee negotiation.
Don't you then have to convert the breaches that you found into some monetary terms in order to get to your value to the extent of breach?
Yes, but, my lord, one does that by adopting an objective evaluation of the rights to the extent they have been breached. So if I can put it this way, by reference to the present case, the learned judge found that there was unlawful competition here in the Thames Valley and West London areas, but not in the West Midlands. So when one comes to apply the Rutan Park approach, one posits a negotiation for release of the restrictions only insofar as they affect the Thames Valley and West London. So one puts out of account the other West Midlands area in which we set a trial, but unsuccessfully. The defendants were also competing. So in that sense, one factors in one's findings on liability. But one is not simply valuing the right in accordance with Professor Stevens's thesis, which is simply to...
No, you've made that clear.
Is it relevant that the Rutan Park case itself and the property case typified by the horse that Lord Shaw spoke of, or Lord Halsbury's chair, are cases where there's been a breach of contract, but there's no pecuniary loss? Well, there's been a breach of an obligation, put it more neutrally, the breach of an obligation, but no pecuniary loss. And the award is being made on the basis that it's being made as a way of assessing a loss of a non-pecuniary nature.
My Lord, we would submit that those cases are compensating for an objective loss, but whether one characterizes it as a financial or non-financial loss, we would respectfully suggest it can be characterized as a financial loss. It is the user principle cases are sometimes described as reflecting a loss of the owner's rights of dominion over his assets. But those are rights that he can turn to account in a financial way. So
the measure would apply even if this particular horse owner never let his horse out by the day.
Mm. Yes.
So it's not. It's a hypothetical, and in certain respects, an incorrect hypothesis. It's incorrect in respects, though, that don't matter to the principle that's being applied.
Yes, my lord, but indeed, but it's reflecting a financial loss. So we, as I will come to it when I deal with the broad proposition, our submission is that there's no sensible or valid distinction in cases involving breach of contract between claims for breach of what might be said to be proprietary contractual rights and non-proprietary contractual
I'm just asking because it struck me there wasn't a financial loss in Rutan Park or Jaggard or the example of the horse. Another example would be Ruxley Electronics. There's no financial loss there because he's not going to rebuild the swimming pool. And one way of assessing the loss of amenity, one might describe it as, would be to say, well, what would he have wanted for waiver of the contractual requirement as to the depth of the pool?
Indeed. And that, indeed, there are those cases where there is a non-financial loss, and in our submission, Ruton Park is just such a case.
Yeah.
But then one asks, why should this alternative approach be confined to cases of non-financial loss? And we say that there's no rhyme or reason for that restriction, that the underlying reason why the court adopts the approach, even in non-financial cases, is because the loss is very difficult or impracticable to quantify in any other way. So the court is faced with a very difficult exercise. It must come up with some solution, and it adopts this solution. Now, that same scenario can play out in a case involving financial loss, and we say that that is the explanation of the several cases where the courts have awarded Ruton Park damages in cases of non-financial loss. And Experience Hendricks is the starting point for that analysis. Lord, can I revert back to that once I've finished going through our broad summary of the nature of Ruton Park damages? And the next point that I would make is that an analogy, there is a useful analogy here, which is the law's approach to reliance loss damages. These are themselves viewed as a form of the court wielding its broad axe. And so, but there the court adopts an alternative methodology of quantifying loss when expectation damages are very difficult or impossible to quantify on a conventional basis. And we say that that analogy is a valid one, and it applies here. And we have set this out in our written case of paragraph 81, page 3587 of the bundle. And it is an analogy that we do adopt. And it shows that the court is willing, where damages are very difficult or impossible to compute on an ordinary basis, to adopt what amounts to a proxy method. Can I then move on to the restitutionary explanation? Because it is our submission that Ruton Park awards may also be explained as a form of restitutionary damages which operate to reverse a wrongful transfer value from the claimant to the defendant.
I'm going to ask you, are you now on to point 3?
I believe I am, my lady, yes.
Well, in the interest of fairness, I took Mr. Behar to task for not telling us where he was in his scheme.
Point 3.
I apologise, my lady. I'm on my third
So
point.
you've completed point 2.
Yes, my lady. So
Which
I'm
you
on
began
point
somewhere
3.
or other. Thank you.
And the key point to understanding the restitutionary analysis is that the relevant benefit obtained by the defendant should be seen as the opportunity to profit from the breach of contract rather than the actual profits realized as a result of exploiting that opportunity. And we submit that the position is analogous to that which applies in unjust enrichment, where a defendant is benefited by early receipt of money. And in such a case, the House of Lords said in Sempra that the defendant's benefit comprises the opportunity to turn the money to account during the period of the enrichment, as opposed to the actual profits that the defendant has made as a result of the use to which the money was actually put. So by analogy, we say that in a breach of contract case, the benefit obtained by the defendant comprises the opportunity to profit from breaching the contract. And that analysis is supported by Professor Peel's analysis of root and park damages in Tritle's Law of Contract. If I could ask the court to take that up, it's Authorities 7, tab 110.
And are you submitting that there is an alternative claim for restitution as such, or are you treating the restitutionary basis as a form of damages?
Lord, we are treating it as a form of damages. It is an alternative rationale for the award of damages.
But it leads to a completely different result. I mean, if the two results coincide, it would be a pure accident.
Well, my Lord, in our submission, not, because whether one is looking at these damages from a compensatory or restitutionary viewpoint, one adopts the hypothetical bargain approach of valuing, on the one hand, what the claimant has lost, and valuing, on the other, the benefit, the value of the opportunity that the defendant has obtained from the breach. And that is precisely what the Court of Appeal did in
But
its
it doesn't cater for the situation where the defendant may make better use of whatever advantage it is than so where the defendant might make better use than the plaintiff of the advantage.
My Lord, in our submission, whether from both viewpoints, one is dealing with a proxy approach, and one has to value the right to the extent it's been breached objectively, and that objective exercise works for both loss and benefit. That is how we put the case, and we say that is consistent and effectively consistent with and effectively what the Court of Appeal decided in Experience Hendricks. My Lady and Lords, if I could ask you to turn up volume 7, tab 110, page 2988. At paragraph 20015, Professor Peel asked the question, compensation or restitution.
Sorry, page again.
Page 2988, my Lord.
Okay.
The concept of a quid pro quo for releasing the covenant is equally consistent with a compensatory or restitutionary analysis, i.e. the claimant is either compensated for the loss of the opportunity to bargain for a sum to release the defendant from his contractual obligation, or the defendant is required to restore the gain made by his breach in the form of the opportunity to generate the profits in question. So that is how we put the restitutionary analysis, and that analysis is endorsed wholeheartedly by Dr. Edelman, and we have cited in our written case a number of articles and passages from his book on gain-based damages, which adopts that very analysis of root and park damages. My Lady and Lords, the second point we make about the restitutionary analysis is that it is essential to distinguish between restitutionary damages which operate to reverse the transfer of the value of the opportunity from an account of profits or disgorgement damages. Those are, we say, two distinct remedies which are based on different principles and produce different quantums. That is important, and it's reflected in the outcome in some of the root and park decisions. In particular, in the case called Pell-Frischmann, which I don't propose to turn it up. It is bundle for the court's note. It is bundle 1, tab 7. But that case was unusual because there the court awarded root and park damages in an amount of $2.5 million, even though the defendant's actual profit was no more than $1.8 million. And the explanation for that is that the benefit obtained by the defendants by breaching the contract was the opportunity to profit from the breach, as opposed to the actual profits that were in the event obtained by them.
Why should that matter if the claimant would not have used the same opportunity to the same effect? And if he would have done, then he will get the thing on the conventional basis. So the whole assumption of this is that the defendant is going to do better out of his breach and he's going to gain more than the claimant would have lost by having less opportunity. Why should that be an appropriate measure of damages if one's valuing what has been lost by the breach?
Lord, we submit that it follows from analysing the benefit that has been transferred from the claimant to the defendant as the opportunity. Now, what was unusual in Pell-Frischmann is that there was clear evidence of a prior attempt to negotiate a buyout, and it is that which led to the court attributing a greater value on the opportunity than the actual profits that were realized. Now, that may be an unusual situation. The only point we make about this is that that outcome is not inconsistent with a restitutionary analysis. Lord, and precisely the same situation applies in the context of the user principle, where again the damages are assessed by reference to the objective value of the right, irrespective of the extent to which the defendant has actually put the property that he has taken, actually managed to turn that use to account. And that is demonstrated by the Inverucci Investments and Hackett case, which we've cited in our case at paragraph 101 at page 3593 of the bundle, where Lord Justice Lloyd gave the famous example of the concrete mixer. If a man hires a concrete mixer, he must pay the daily hire, even though he may in the event not have been able to use the mixer because of rain. And that, we say, explains the result in Pell-Frischmann. And the final point, which I've already made, is that we say if one is adopting an objective approach of valuing the right that has been lost by reason of the breach, there will be correlation between the claimant's loss and the defendant's benefit. And so for that reason, for example, Professor Peel goes on to say in Tritle that generally it will not make any practical difference whether a restitutionary or compensatory explanation of root and park damages is adopted. But whichever viewpoint is adopted, the same justification applies. That is to ensure that the claimant is not undercompensated. And that is accepted, for example, by Professor Burrows in his book on the law of restitution, Authority 7, tab 100 at page 2843, where he describes root and park damages viewed from a restitutionary perspective as being designed to meet a concern that difficulties of assessment mean that compensatory damages will not put the claimant into as good a position as if the contract had been performed. Now, Professor Burrows describes root and park damages as being exceptional, though he draws a distinction between root and park and disgorgement damages, which he says are more exceptional. We would quibble with him insofar as his description of exceptionality applies. But we do make the further point that in Professor Burrows's a restatement of the English law of contract, he sets out the view that root and park damages are not exceptional and that they are a valid alternative to ordinary compensatory damages that should be generally available. And given the time, if I can just refer the court that it's at at page 2792 of the bundle, that's Authorities 7, tab 97. Lady and Lords, my next exercise was to canter through the main authorities. And if I can start with Rootham Park. This is volume 1, tab 10. Now, we submit that the best explanation of this case is that it is a case of non-financial loss. The development of 14 houses on the plot of land in breach of the restrictive covenant clearly caused C no financial loss, because the pecuniary value of the estate wasn't diminished by 1 farthing. There was also no genuine loss of opportunity to bargain. But we suggest that Mr. Justice Brightman recognised in his award that some form of non-financial loss, akin to loss of amenity or loss of control over the environment, had been suffered. And that is what he was doing. He was compensating the claimant for that loss, albeit on an objective basis. And we draw the court's attention to start with passages where Mr. Justice Brightman was dealing with the question of whether the restrictive covenant was enforceable. And if I can pick it up at page 858 of the bundle. So in a sense, this was not a breach of contract at common law, but in all other respects, it was a breach of contract case. The only difference is that because of the equitable doctrine in Tulk and Moxey, the contract was enforceable both by and against assignees of both the covenantor and the covenantee. But we say in principle, the result on damages should not differ depending on whether the claim is between the original parties or between assignees to those original parties. And that is precisely what Lord Justice Peter Gibson said in Experience Hendricks. So it is right to treat this as a breach of contract case.
Can you enforce or take and enforce a restrictive covenant over neighbouring land which you have given away?
Which you have disposed of, milady?
Well, that's
Fortuitously, i.e. not by way of contract.
I think so.
I think you can, can't you?
Yeah.
Yeah.
I see why not.
I mean, the point about a restrictive covenant is that it goes with the land for the benefit of the dominant, if one could call it that. That's not quite the right word, but
It's a reservation on the transfer of title, which is enforceable whatever the terms of the title, of the transfer.
so that's why it's rather difficult invariably to regard it in contractual terms.
But, well, milady, perhaps I should then start with this passage. At page 864F, it's clear that I would respectfully suggest that Mr. Justice Brightman regarded himself as awarding damages for breach of contract. As he says there, I turn to the consideration of the quantum of damages. I was asked by the parties to assess the damages myself. The basic rule in contract is to measure damages by that sum of money, which will put the plaintiff in the same position as he would have been in if the contract had not been broken.
Well, I suspect what he's doing there is he is saying, well, what we've got here may not be contractual, but it is an obligation. And therefore the analogy that's appropriate is the measure for breach of contract. It's a breach of an obligation rather than necessarily an invasion of a proprietary right.
Indeed, my lord, we would accept that analysis. But when it comes then to analysing the award, it is properly analysed as an award for damages for breach of contract.
No, it's properly analysed as an award for something which, in the relevant respects, may resemble a breach of contract.
My lord,
but isn't one.
Technically, but we would respectfully submit that that there should be no difference in substance.
What matters is whether it's a personal obligation or an obligation.
Well, my Lord,
He
our
then goes
submission-
on to talk about a different situation,
Specifically,
the Wayleaf cases. He's searching for a proper principle in which to deal with this particular set of facts.
I think it's also relevant, as my Lord said, that the owner has an interest in the maintenance of the estate, quite apart from whether he's damaged by the particular
Yes.
feature bit. I mean, I think it's
It-
because that's one of the things he discussed at page 880 to 860 to 861, that it is that the owner still has a reasonable interest in, or the beneficiary has an interest in maintaining it, then it should be upheld.
Indeed, my Lord, and that is where we base our explanation of this case as being one that is compensating for loss, albeit a loss that is very difficult to conceptualize and quantify.
Well, a loss which is non-pecuniary.
Yes, in this case, my Lord, yes, indeed.
I mean, he was being asked to order that the houses be pulled down. He says, no, I'm not going to do that. Then he turns to Lord Cairns' Act or its successor and says, well, I can make award damages in substitution.
Yes, my
So
Lord.
there's that sort of,
Yeah.
Yes.
that's the way in which the issue is held, isn't it?
It is, my Lord, but what we respectfully suggest is that one has to analyse why those features should have made any difference.
It might be worth, and we're coming out to 4 o'clock, I did mention earlier the case, Court of Appeal case SJC against Sutton Council, which is quite interesting because it's the Court of Appeal applying Rootham Park in a case where what they were concerned was whether there's loss or damage under Section 84 of the Law of Property Act. And there they're saying, well, yes, it's really a disadvantage, which is non-pecuniary, but nonetheless, it's a proper way of assessing it is to adopt a Rootham Park approach.
Yeah.
So it's quite an interesting illustration to point to, my Lord.
The Jimi Hendrix case is another example. No pecuniary loss, but an award made on Rootham Park principles.
Well, my Lord, we respectfully disagree with that analysis.
well, no doubt you'll come to that tomorrow.
I'll come to that tomorrow morning, that we say Experience Hendrix is indeed a case of financial loss. There was financial loss. It was both identified and identifiable, and the financial loss was the loss of profit on the sale of genuine Jimi Hendrix recordings, which had been diverted and displaced by reason of the unlawfully licensed sidemen recordings going onto the market. And there's express discussion.
I thought it was his reputation that he was trying to protect, and that the interests in the rights did not belong to the claimant. I may have got the facts wrong, but that's what I recall.
Well, perhaps we'll go on to that case and your analysis of the case, and we'll look at it tomorrow. That seems an appropriate moment at which to adjourn, and we shall look forward to hearing from you further. 10:30 tomorrow morning.